can a party that entered into an agreement that has a sole and exclusive remedy provision preventing a lawsuit for a breach file a lawsuit for anticipatory breach? To find out, you have to read Audthan versus Nick and Duke, but it's 16 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Audthan versus Nick and Duke. The citation for this case is 2024 New York Slip Opinion 02223, published by the New York Court of Appeals on April 25th of 2024. The issue in this case is whether an exclusive remedy clause in an agreement means that a party cannot sue for anticipatory repudiation of that agreement. I'll explain all that in a few moments. This is a little complicated and hard to do this in 5 minutes. I'm going to try my best. Some background is that an anticipatory breach of an agreement is when one party to an agreement, before the time arrives to perform under that agreement, says conclusively, unequivocally, expressly, and absolutely that they will not perform under the agreement. If they say before the time arrives to perform, I will not do it, that is an anticipatory repudiation, an anticipatory breach, and the non-repudiating party can claim damages for a total breach in that event. The other thing you have to know is that under 3211, which is a motion to dismiss, under civil practice law and rules 3211, the court, when assessing a motion to dismiss, has to liberally construe the pleadings, accept all the facts as alleged is true, and give the non-moving party, the party that made the complaint, every reasonable inference and favorable inference, and determine whether the facts as alleged fit within any cognizable legal theory. All right. So what are the facts in this case? The facts are, this is a real estate agreement. There's two parties, Nick and Duke, which owns a building in Manhattan, which is occupied by a single room occupancy hotel and rent stabilized tenants. And the other party is called Audthan. Audthan is a real estate developer. In 2013, they enter into an agreement where Audthan will get a lease, a 40-year lease, followed by a 48-year lease, followed by Nick and Duke getting the property back. And in that agreement, Audthan's going to convert this building, this property, into 58,000 square feet of luxury residential and commercial building, and also 15,000 square feet of low-income housing, because before this agreement was ever entered into, there had been a previous harassment complaint that had been filed with the Department of Housing Preservation and Development, and ultimately they had been found to commit some kind of infraction. And so the New York City HPD required that 15,000 square feet of this building be set aside for low-income housing. Okay. The important part of this agreement, and the part that becomes important for this case, is that there's a sole exclusive remedy provision. 3309 of the lease says that the consent of either party, if either party's consent is required, they shouldn't be unlawfully, it shouldn't be unreasonably withheld, conditioned, or delayed unless specified. And it says that each party waives to the fullest extent of the law any right to damages based upon any party's failure to give that consent. And finally, it says the party's sole remedy, if a party wrongfully withholds, conditions, or delays consent or approval, shall be the right to seek an injunction. Okay, go to court and make me. That's what that means. Okay. So while they all understand in the course of this contract, this agreement, that HPD will not allow them to do anything that they want to do with this development unless they get a cure, unless they get the previous harassment finding cured by HPD. And while they're trying to figure out this cure agreement, Audthan gets sued by multiple of these tenants, gets sued by multiple of these tenants for wrongful eviction. So ultimately that gets resolved where four additional units have to be put aside for rent stabilized tenants. Ultimately, so now more and more properties being set aside for low-income tenants, and less of the square footage is allowed to go to this luxury property that they intend to make all their money on, presumably. So they finalized the cure agreement, and N&D refused to sign it. N&D said, "I'm not going to sign this because the numbers don't work. The numbers that we agreed upon, the numbers we thought was only 15,000 square feet and 48,000 or 58,000 square feet of luxury. Now the numbers are different. The proportion's different." So N&D refused to sign the cure agreement. So Audthan, using that sole exclusive remedy, brought N&D to court in 2016 and said, make them sign it. The court refused to make them sign it, saying that they were, it's possible they had a good reason to sign it. Ultimately, they keep litigating this HPD cure agreement, and finally, N&D sends a letter. N&D, which is one of the parties here, sends a letter to the HPD, to the New York City Housing and Preservation Department, and says, we will not sign any cure agreement. At that point, Audthan sues N&D, brings a lawsuit. Doesn't follow that exclusive remedy provision where you make me. They actually file a lawsuit, and that's what we have in this case. They file a lawsuit with a bunch of different provisions, including a claim of anticipatory repudiation, saying that that letter N&D sent to the New York City Housing and Preservation Department was an anticipatory repudiation. They said, we're not going to sign anything. We will not sign any cure agreement. At that point, N&D, Nick and Duke, moves to dismiss under 3211. And the procedural history here is Supreme Court grants the motion to dismiss. Appellate Division affirms. But here it goes to the Court of Appeals. And they say that under 3211, think about what they have to do. Under 3211, we're only looking at whether the facts as alleged constitute an anticipatory repudiation. And they do. They say here, the letter in which N&D said they would never sign the cure agreement sufficiently alleges an anticipatory breach. The only other question here is whether that sole remedy provision bars the action, whether it does not allow them to file this lawsuit. And they say that was not fully preserved below. And so the only question before us is it sufficiently alleged? And it is. So they reinstate, they reverse, they allow the case to go forward with respect to the anticipatory repudiation. And that's the case of Audthan versus N&D. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.